Hello everyone, welcome to the International Commercial Arbitration class. Today, we're going to discuss the chapter 4 and that is the commencement of the arbitration and the appointment of the arbitral tribunal. We are going to talk about when, where, and how are we going to start the arbitration process. So as we're going to learn also on how can we select the qualified arbitrator to mediate in this situation. The process of commencing arbitration proceedings will depend on the provisions of the arbitration agreement, the law governing the arbitration proceedings, and any institutional or other rules that the parties have agreed should apply to the arbitration. For example, if you are a foreign investor or businessman and you had requested for Korean Commercial Arbitration Board, you're going to use the rules. The standard procedure is that a party intending to have recourse to arbitration under the rules shall submit its request for arbitration. So initially, you have to file first the case, you have to file first the complaint before the commencement of the arbitration will happen or will start. At the end of this chapter, the students will be able to understand the commencement of arbitration and appointing of arbitrators. Let us try to familiarize with applicable rules and law regarding to the appointment and commencement. And lastly, let us also understand on how we could appoint a tribunal and arbitrator that is related to the situation. Before we proceed on the process of commencement and appointments of arbitrator, I would like to give some clarification on the different important terms that we are going to use in this chapter. Our first term is commencement, meaning a beginning or start. In Korean, you say commencement as 졸업식입니다. 졸업식입니다. Okay, so this is a term that will describe the start of a process. Okay, the second term that I would like to emphasize is the word agreement. This is a position or a result of agreeing, meaning both party, the buyer and the seller, agree for a particular condition or a particular um, regulations. Example, buyer and seller agree that they're going to follow the Korea Commercial Arbitration Board. Remember, those who can only use the Korea Commercial Arbitration ruling are other state other than Korea, meaning Korean nationalities or Korean business firm could not use the rules and regulations of KCAB because it would be biased if Korean is going to use rules and regulation because of the it may favor Korean. Okay, so to prevent that, the KCAB is intended only for the foreign business or foreign company. In Korean, you said agreement as 동기합니다. Next, we have nominating. The third term is nominating. It means propose or formally enter as a candidate for selection. Okay, you suggest, okay, of who will be the potential arbitrator. In Korean, you said nominating as Jim Jim. The fourth term is appointment. It means that assigning a job or position to someone. When you already nominated and selected the arbitrator, the selected arbitrator will be appointed. So in Korean, when you say appointed or appointment, it means the word used is 임용하다. 임용하다. And the last term that I would like to emphasize is the word advance payment. So this is a payment due, okay, in advance per goods or services, because in arbitration, some arbitrators are requesting for advance payment. In Korea, you say it songgupkum, songgupkum. These are some of the practices, okay, if you would like to use the arbitration process. So we have the four terms: commencement, agreement, nominating, appointment, and advance payment. In the Article 21 of the United Nations Commission on International Trade Model Law, or the Ancestral Model Law, it provides that unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which the respondent receives a request for that dispute to be referred to arbitration. In litigation, we call it like subpoena. Once the respondent, okay, had received the subpoena or the complaint letter, that could be the time that the commencement of the arbitration will start. Again, the claimant is the complainant, then the respondent is the suspect or the offender. Okay, commencing the arbitration may be dictated by the agreement to the arbitrate that forms the basis for the arbitration. Arbitration is at its core consensual in nature. It must be agreed by both party, the buyer and the seller. Okay, so when you start the commencement process, again, it should be covered, or it should be accordance with the applicable law that the buyer and the seller had agreed upon. We have to remember that the manner of starting the arbitration depends upon the relevant arbitration rules. So if both parties had decided to use institutional arbitration, like American Arbitration Organization, London Commercial International Arbitration, International Commercial Arbitration, ICC, CIETAC. Okay, so they have to follow the standard rulings on how they are going to start. But in general perspective, once the respondent had received the complaint letter or had received the subpoena, they're in the process of arbitration will start. So if they're going to follow the ad hoc arbitration, they can use the unsettled arbitration rules or their national law. Okay, remember the rules and regulations to be followed must not be on the side of both a complaining party and the respondent party. When we start the commencement of the arbitration, there must be what? The consideration is, of course, by logical reasoning, there must be a dispute. Okay? The first process of arbitration is that the case was being filed to the tribunal court, and it will start if you already pay the arbitration fees. Remember, the proceedings or the process of arbitration will depend on the standard arbitration clause that is written in the contract. For example, I'm going to state a particular statement telling you, okay, or stating that if you use AAA, ICA, or LCA, it should be written in the contract. Like, okay, the clause says like this: any controversy or claim arising out of or relating to this contract or the breach thereof shall be settled by arbitration administered by the, okay, then you state the name of the institution, American Arbitration Association, under its commercial arbitration rules. So it is very clear that you have to state the ruling and the institutions, and judgments on the award rendered by the arbitrators may be entered in any court having jurisdiction thereof. Okay, so it must be clearly stated. What are the limitations of rules and regulations? First is time limits for bringing dispute, either contractual or statutory. Remember, if one party is not cooperating with the process, definitely it could prolong, okay, the procedure of arbitrations. Remember, the arbitration process will start by the time that the respondent receives the complaint letter or the subpoena. So if in case that the respondent, okay, is not cooperating with the procedure, definitely it would take a lot of time. Number two, number of arbitrators. Case in arbitration, there is no limit. Okay, of course, depending on both parties. The more arbitrators, the more you are going to pay. So no, normally, they give the maximum number of arbitrators up to three. Okay, that is the standard of ICA. For American Arbitration Association, upon the filing of case in their institution, you will be given 10 names of the qualified neutrals. Both party is going to give an opportunity to select, okay, who will be the arbitrators. Okay, the maximum number is 3. The more arbitrator, the more arbitrators fee that you are going to pay. If both party, okay, could not able to decide, the American Arbitration Association is going to give them 14 days to select. If it is not returned to the AAA, then that could be the time that the AAA will decide, okay, who will be the roster of neutrals. When you say neutrals, that is also the arbitrators. The first step in arbitration process is the filing of complaint. It will be initiated by the claimants. So if they had decided to use the American Arbitration Association, they're going to submit a certain requirements. Okay, they are going to file with AAA a demand for arbitration form, the administrative filing fee, and a copy of the applicable arbitration agreement from the parties' contract which provides for arbitration. In small or large dispute, judicial resolution does not come with the added cost, only the filing fee. Okay, but of course, it's a business, but make sure to assess this kind of institution. Okay, in the Article 4 of the ICC rules, it requires the claimant for advance payment. Okay, you should pay the arbitrator's fee and the tribunal fee. The proceedings will not take place if there's no case being filed in the tribunal court. That's why it is the responsibility of the filing party to ensure that any conditions, okay, or requirements, okay, needed in filing a case should be met, okay, prior to the arbitration, because it will not materialize if they did not pay a certain fee or they did not apply for the proceedings. So what are the information that should be included with any arbitration filing? Okay, they have different forms, okay, so you have to comply with those documents. But initially, you are going to file the case, including the information like the name of each party, the address of each party, the contact number if applicable, okay, and if there will be a representative, so you should include that also in the filing. Okay, and then the statement setting forth the nature of the claim, so it's like the your your statement, okay, of the nature why you are complaining, okay, and the relief sought and the amount involved, and lastly, the local requested if the arbitration agreement does not specify one. So in your statement, you have to state there also about the request of the institutions to undertake the proceedings. So all of this information in a document, okay, you have to provide, okay, the claimant, okay, should provide or submit these documents also to the respondent. Let us simplify the steps in filing the case in arbitration. So take note, we are only in the process of filing the case in arbitration tribunal. First, the claimant should submit the following requirements to the office of the arbitration tribunal. What are the requirements? The number one is the demand of arbitration application form. Number two is the sworn statement, which means that whatever the claims, the nature of the dispute, okay, whatever she wants or he wants to get from the respondent in like money or replacement or the fulfillment of the contract, it should be in written statement. Then third is a proof that there's a business transaction that had been done between the buyer and the seller, that is the contract. And the fourth one, it is also necessary that you provide the information of claimant and respondent. If you were able to complete the requirements, then you have to pay the arbitration fee, and then you will be given a copy of the demand letter, and the arbitration office is going to send the demand letter to the respondent. And if the respondent receive the copy of the demand letter, and then the arbitration process will start. What are the different costs or fees and expenses that you may encounter in filing the arbitration? Number one, this is on the aspect of the arbitrator's fee, not with the aspect of the processing fee. In American Arbitration Association, the initial cost for the arbitration is around $75,000. Okay? Because in arbitration they are not resolving a conflict wherein the amount of damage is only around $1,000. It is more on $1,000,000. Okay, so those are some of the natures and the amount of the damages that been happening in international commercial arbitration. Okay, so these fees are intended only for the arbitrator's fee. Okay, number one, we have ad valorem. So this kind of method, you're going to pay the arbitrator within the like a percentage amount. Okay, 5%, 10%. Here in Korea, I had encounter with the arbitration process wherein that 10% of the total amount to be lump sum or to be collected with the company will be given to the lawyer. That is the standard that I had experienced. So more on 10%, 10%. And next is the time spent. So you are going to pay the arbitrator only in the manner of the hour that he had been spent, okay, the time he had spent, okay, during the process of arbitration. Okay, so that is more on hourly rate. Okay, and this is the common method. And the last one is the fixed fee. So mostly the institutional arbitration organization, they set a fixed amount on how much you are going to pay. That is what we call the fixed fee. Here are some of the example on the method of payments of different international commercial arbitration. For American Arbitration Association, they have a method of uh, per hour rates or per day payment. Okay, so that's the system of payment in AAA. For International Chamber of Commerce, no fixed fees. They set fees after the case resolution. This kind of difficult because um, it is uncertain or it's not yet determined the amount how much to be paid. So the tendency is that depending maybe of the amount that the claimant will receive from the respondent. So um, much better, okay, you should set the payment, okay, and written it in the arbitration agreement, okay. And the third one is the London commercial arbitration. They have a fixed rate, okay, they have that fixed rate. So on this system, it kind of more safe, okay, for both buyer and seller, so that the institution is not going to take advantage with the amount that they're going to pay to the institution, okay. And the last one is ad hoc, no set ruling, because they do not follow a certain policy of the institution. They could set their own fees unless they're going to get a professional, and the professional arbitrator is going to ask for or demand for a particular amount. Now you already filed the case in institutional arbitration tribunal. Okay, how can we appoint or how can we choose an arbitrator who will mediate with the dispute? Okay, there are several ways on how you could appoint an arbitrator. Again, this is depending on the institutional standards of arbitration. For institutional, the institution could give you a roster of or the list of arbitrators name and profile. But for the ad hoc arbitration, okay, you can appoint whoever you want to be the mediator of the dispute, okay. The appointment of an arbitrator can be done through by agreement, okay. So commonly, this is the commonly used method, okay. So the buyer and the seller is going to select an arbitrator, okay. Or number two is by use of list system. American Arbitration Association, they really provide 10 names, okay, of arbitrators wherein the client or the parties is going to select. Number three is appointment. Okay, appointment is a mechanism of the applicable arbitral organization. Okay, so they're just going to appoint. Okay, or you could be the arbitrator, something like that. Okay, and then next is by nominating of arbitrators. Okay, so the buyer and the seller is going to nominate, okay, the potential arbitrator that could help them to resolve the dispute. Then number five, by means of listing the president or senior officer of a professional institution or trade institution or association. So you could also select from the different heads or the presidents or the officers of a particular trade association. Make sure they don't have any affiliation for both buyer and seller. Then number six is by national court. If you apply for arbitration in the court, they're going to give you the arbitrator. Okay. So in American Arbitration Association, what they are doing is they give the list, okay, to the party, and then they were given 14 days to select. That if in case they fail to select the arbitrator or to appoint an arbitrator, the American Arbitration Association is going to pick or select an arbitrator for them. Then the last one is by designation of some other authority to appoint the arbitrator or arbitral tribunal. Okay, so if you go to the court or if you go to some um, institution, okay, they could designate. Okay, it's also similar with appointment. So when you say designate, this will be in the will of the institution, not with the choice of the party. Okay, because if you fail to select the arbitrator, the association is going to provide or they're going to designate a particular arbitrator. What are the standards of appointing an arbitrator? Okay, some parties may find desirable the opportunity to interview and scan the profile of the arbitrator. Okay, so you have to consider a particular qualification, like it should have an experience. Some country requires it to be a lawyer. In Chile, they want it to become a lawyer. They want to choose an arbitrator who is a lawyer, and then has a relevant knowledge with the dispute. Okay, the arbitrator should have a knowledge and a lot of information about the dispute. To be specific with the qualifications of the arbitrator or tribunal, okay, I have here the list. First, it is a requirement for an arbitrator to have an industry experience. Okay, it is not mentioned how many years, but as much as possible, the arbitrator should have an experience in relation with mediation, okay, or resolving dispute in this kind of setting. Secondly, one of the qualifications is that an arbitrator should have a legal and technical expertise. Okay, meaning the person who is going to be appointed to become an arbitrator should have a technical expertise in terms of the nature of the dispute, how it will be done, okay, how to gather evidences, how to hear or to evaluate the sworn statement, okay, and so that they could be able to know, they could be able to give an award or a decision based on the evident relevance to the dispute. Third is arbitrator availability. Okay, of course, the RVC, okay, is more than 1 million every year, wherein the business transaction that encounters some dispute. So one way or another, okay, there will be insufficient availability of an arbitrator. So he should make himself, or he should be available on the set date of the proceedings of arbitration. Next is the familiarity with applicable law. It is a basic requirement. Okay? They should have a knowledge with the state law, with applicable law, okay, and also the ruling that the party had chosen to utilize throughout the arbitration process. Next is the next qualification is that arbitrator should have a management skills, okay, in relation with the computer, documentation, and transcript. He should know how to interpret the data like a researcher. Okay, he should know how to evaluate the sequence of the event. Okay, because the contract is bounded with timetable, and the eventuality that is not within the contract period, okay, should not be considered. Those are just some of the important things that you have to remember as an arbitrator. Okay, of course, you have to be computer literate and familiar with the different requirements or the documentations as the basis of evidences for the ruling in arbitration. Okay, and lastly, the arbitrator should know the ethical values and some guidelines and standards about gender, racial, and ethnic diversity, as well as the culture of arbitrator is also a concern. Why? Because somehow it could influence the manner of decision making. Culture and ethnic diversity has some factor in decision making, because we are dealing with international dispute here. So one way or another, the culture or political influences or perspective or some beliefs or perception in a matter may be affected. That's why we have to consider the gender, racial, and ethnic diversity of the arbitrator. Additional traits or attribute of the members of the tribunal court. Number one is, of course, we emphasize the availability, okay? Because the arbitrator should make the proceedings a priority task for him or for her, okay? Because remember, one of the characteristic of international commercial arbitration is the manner of proceeding is fast. That's why the time should not be a constraint. Okay, the time should be complementing to the time of both buyer and the supplier. Okay, the time of the arbitrator, okay, should follow the availability of the buyer and the supplier. But of course, everything is agreeable, so they could manage to set the available time for both a party and the arbitrator. Next is the fluency in English. Take note, this is dealing with international commercial arbitration. So we could expect that uh, the both party is using a different language. Okay, so English is not their mother tongue. That's why, as much as possible, okay, we should choose an arbitrator who is fluent in English. Okay, and the last one is independent and impartial. To implement justice and fair decision making, we have to evaluate the arbitrator discretionary skills, meaning in terms of decision making, he should not be influenced by different factors from both parties. He should be independently decide on the manners and the basis of the evidences that had been presented during the proceedings. Always remember that both party could have an agreement of the appointment of the arbitrator. Okay? In that case as well, both party could be able to remove or replace the arbitrators when, okay, they have to remove or when to remove or replace the arbitrators. Okay? Number one, when there are justifiable doubts. Remember, one of the qualification of the arbitrator is they should work independently, and when they decide, it should be not biased. Okay, so in case that arbitrator is unable to perform his function in provision of justice for the both party, that could be one of the reasons that the arbitrator will be removed or replaced. Secondly, arbitrator lacks qualification. That's why it's very important that prior to the proceedings, you have to scan, you have to evaluate the qualifications of the arbitrator technically, behaviorally, okay, and then in terms of communication and intellectual capacity of the arbitrator should be sufficient or to the supreme level, okay, to uh, to mediate and to solve the dispute. And lastly, when arbitrator is prevented from fulfilling his function, like inevitable situation like illness or some situations like family problem, or he was being engaged into an accident, so that could be the reason that you can remove or replace the arbitrator. Some other reasons, like if the arbitrator himself withdraws from his office and arbitrator fails to act without undue delay, okay, like he's not fulfilling his job. If an arbitrator becomes legally or practically unable to perform his function or withdraws from his office, the court can be approached to decide on the termination of the mandates of the arbitrator and appointment of another arbitrator. Otherwise, it should always be agreed by both parties. What are the obligations and power of the arbitrator or tribunal? Number one, he is responsible of adjudging or to make a decision in the matter of the dispute. He needs to confirm if the claimant is telling the truth or he has the reason to claim that he had been offended or there's some damages in his part. Okay, and he has a responsibility also to prove if the respondent is guilty of the verdict or he is not responsible to any damages happen in the dispute. Okay, so also Albeit means although informally. Okay, so even the proceeding is in a formal way, he's still is responsible to give decision on the matter and the basis of the evidences. Okay, and secondly, to assist them in accomplishing the following tasks. What are the following tasks besides from the giving an award or making a decision with a dispute is to what? Formulate the arbitration agreement. Okay, in the process of writing the arbitration clause or agreement, the arbitrator must be included. Why? For him to give guidance for the buyer and the seller or both parties or the claimants and the respondents. And the arbitrator is also there to help the party to select applicable law, because some parties doesn't have any knowledge with the law. Okay, so the arbitrator is going to give them some enlightenment and explain some of the important terms and the process of the arbitration. Our chapter 4 is very short. I only concentrated in the appointment and the commencement of the arbitration proceeding. Okay? It is really important that we understand how are we going to select the arbitrator, how are we going to start the proceedings, okay? Especially what kind of documents that we need to submit, and in case that we found out that arbitrator uh, is not qualified to be the arbitrator or mediator to resolve the dispute, okay, both parties have the privilege to change, remove, or replace the arbitrator. Again, the standards of proceeding in appointment and starting of arbitration process is depending on the standards, depending on the rules and regulations of the appointed institution that both party had chosen. Remember also that everything, okay, every decision that is written and every decision that had been made is a consensus, meaning it is agreed upon by buyer and seller. I hope that you learned a lot from our chapter 4, and if you have any further question, please send me a message. This is your professor, Dr. Christine Joy Simpao. Thank you and have a nice day, everyone.